The Oni case, where the Supreme Court held that even if the leadership of a political party is questionable, their right and competence to sponsor and nominate a candidate is unquestionable in court. And so that is what has played out today. There's nothing like lack of structure. And then also you will also find that the Congress they said never held is actually a subject matter that no court can deal with. You also had it in court, that it is not for any court to determine whether that Congress was valid or invalid.
The issue before that we brought before this court is whether there was compliance with the order of the Court of Appeal of 28th of October 2022 that says that you must go and comply with the order, and your failure to comply with the order, then you cannot partake in any election. And that now dovetails into whether anybody sponsored by such party in the civil court order has a valid sponsorship.
The Plateau governorship case is one of the most anticipated in the list of governorship appeals at the Supreme Court. Governor Caleb Muftwang is praying the Supreme Court to dismiss the Court of Appeal's decision in November last year, which voided his election on grounds of non-qualification. The appellate court had in a unanimous decision held that since the Plateau State PDP did not have a party structure, its Congress were invalid. With Muftwang's nomination being an offshoot of the exercise, he became a casualty, with Ntawe Yiltwalda of the APC emerged winner. The matter on lack of party structure arises from a Plateau High Court decision which ordered the Plateau PDP to conduct a fresh Congress, an order which the APC insists wasn't complied with. As such, the issue of jurisdiction of either the High Court to make an order on the conduct of party congresses and that of the Appeal Court to void the election of Muftwang was the dominant issue. Kanu Agabi, counsel to Muftwang, insisted that the Appeal Court departed from the judgment precedents of the Supreme Court, which states that matters on nomination was a pre-election issue, one that it lacks jurisdiction to determine. Agabi also faulted the decision of the Appeal Court to declare the APC governorship candidate winner of the March 18 polls, which he had deemed, quote, invalid and null and void, in his appeal at the tribunal, which affirmed the election of Muftwang. The argument of the APC at the tribunal bordered on qualification, invalidity of election, and majority of lawful votes cast, with the Appeal Court basing its decision on qualification. Counsel of Ntawe Yiltwalda and that of the APC prayed the Supreme Court to uphold the judgment of the Appeal Court, sacking the Plateau State Governor for being a product of a party without structure. The Apex Court has also reserved judgment on the Delta State governorship appeals filed by the governorship candidate of the All Progressives Congress, the Social Democratic Party, and the Labour Party.
We believe that even in the proceedings today, we got an additional opportunity to bring clarity to our arguments.
We didn't have enough time to go into our case the way we would have loved to. But we did the best we could.
Hearing of more governorship appeals will continue on Wednesday.
Filed by coming from the Plateau State and also the Delta State. But that of Plateau State, the governor was in court. From his body language, he was excited because usually hearings gives litigants an incline on the direction the court will toll, but not to preempt the court. Looking at the argument and the question asked by the justices to the various respondents, the case that the governor brought before the court is seeking to overturn the judgment of the Court of Appeal that nullified his election. The tribunal at the stage affirmed his election, stating that the issue brought by the APC is a pre-election matter, and as such the court lacked the jurisdiction, and it is an issue of qualification, sponsorship, and nomination. But at the Court of Appeal, the Court of Appeal nullified his election, stating that qualification and sponsorship or nomination is both a post-election and a pre-election matter. But at this very point, which is the Supreme Court and is the last stage, the counsel to the governor has told the court to overturn the judgment of the Court of Appeal and affirm his election on grounds that the APC had no right to actually question how a party conducts their congresses. That has been the position up to the Supreme Court in various cases. It is an internal party affair, and the party and the other opponents or the party has no right to question. But the argument of the respondent is the fact that there is a valid subsisting court order that the governor is in, and his party is in violation of. And this was an issue between the PDP. The PDP had an issue internally. They went to the lower court up to the Supreme Court, where the Supreme Court asked that congresses should be conducted in 17 local governments. But the argument of the APC is that PDP only conducted congresses in only 5, leaving out 12, which is in violation of a court order. But the case now, even as though it was the PDP within themselves that came to the court, does the APC have a right to interfere in that matter using that judgment to want to nullify the governor's election? Because the argument of the APC is the fact that the governor is in violation of a court order. But these were the issues raised,